Well, welcome everyone, and thank you for joining us today. My name is Amy Dickerson, and I'm here today with my colleagues Jared Costanzo and Koga Ndikum-Moffor for one of our firm's monthly webinars where we discuss for 30 minutes on the third Thursday of the month a focused topic that may be top of mind for administrators. So with the school year fast approaching and even underway for some of you, we do know that some of you are facing already various types of residency questions or have been through the summer that can sometimes present some nuanced, unique issues. While some of you might be new to a role that requires you to assist with residency issues or homelessness issues for the very first time. So our goal today will be to provide both an overview of the laws regarding student residency and enrollment, as well as the laws governing the rights of homeless students, and to offer some frequently seen issues and topics that we see that come up with these, while we go through so the fundamentals of the law to hopefully provide you some practical tips along the way. Before I begin, I did want to just note a couple guidance documents that we think can be extremely helpful, especially for those of you who are new to these roles, as well as a resource that our firm offers. So the first guidance document that I want to direct your attention to is ISB's non-regulatory guidance entitled the Registration Guidance, Residency and Enrollment, Immigrant Pupils, Homeless Pupils, and School Fees and Waivers. This is a sort of standing document that ISB has under their non-regulatory guidance on their website. And it really is a good resource to get some baseline knowledge, especially for how ISB views these various issues. We will review the content of that guidance during our discussion today, but this is a great guidance document to take a look at, not only as you're working through enrollment situations, and of course, always working with legal counsel can assist with that as well, but it can also be a great guidance document to just review in advance of having any particular issue, just to really have a good foundation of these issues, especially for those of you who are new to these roles. Second, the second guidance document that I just want to draw your attention to is ISB's policy on homeless students, and particularly the dispute resolution process that governs the procedures that have to follow and have to be followed when a school district and a family may have a dispute as to a student's eligibility for rights and services under our federal and state laws governing homeless students' rights to education. This document that ISB has, while it can be a little dense, it provides an overview for the process that must be followed when a dispute arises of a student's homeless status. And so, as we'll discuss, because students who report or present as homeless must be immediately enrolled, there is a very particular procedure that must be followed when a district challenges a family's assertion of homelessness. And finally, and I'll raise it now just because we will likely reference it during the webinar today, we do offer a residency toolkit containing template forms for districts to use to have their families provide and complete when they are providing the residency verification information. It has some particular forms that address unique living situations. And it also contains sample notices and communications to send to families when a residency dispute might arise. So if you are interested in getting additional information about that toolkit, feel free to reach out to any one of us or allmarketing@franczek.com. So with that, we'll go ahead and dive in. If you do have any questions, please feel free to submit them via the Q&A on the Zoom webinar function screen. And of course, if there's any questions that are lingering after our time today, because I know that it's brief, you can always feel free to reach out to us. But we have had a number of questions recently and over the past school year that really involve a determination of, sort of the crux of the issue of whether a student and parent's asserted residency situation is actually consistent with the information that they are providing the school district. For example, you might have a student, let's say the student's name is Aaron, whose parent comes to enroll them, provides documentation that the parents own the home in the district and has copies of current bills. But then the mom makes the comment at the time of enrollment stating that they moved into the district because the schools are so great and they wanted their kids to attend the district. Or the mom says that they also have a home in a neighboring suburb where they still return to on the weekends. Or the mom might say, we might have a scenario where the mom says that the student will actually be living with her aunt, who lives in the district while the mom resides out of district. And it's unclear to the district at that point whether the aunt has short-term guardianship over the child. So in any given scenario that the scenarios I just presented, might present for a district, where should you begin? Well, the first really is confirming, which rules are going to apply to this student, whether the student specifically receives is in the general education of the school, or whether the student has an IEP and receives special education services. The reason why is that, as many of you know, there are slightly different rules under our school code that apply for residency for students receiving special education services. So let's go through some of those basic rules now, and then I'll jump in and sort of identify how those might apply to the scenarios that I just posed about our hypothetical student, Aaron. So let's say Aaron is a general education student. Jared, do you want to go ahead and take us through the rules for residency for general education students under the school code?
Sure, Amy, thank you. So for general education students, the key for identifying a student's residence all comes down to what legal custody means. So legal custody, for the sole purpose of determining the residency of a student for school, can be one of 5 things under the school code. The goal of the school will be ultimately to decide, which one of those 5 situations most clearly reflects the reason the student lives in the district. So for the first situation, if the student lives with his or her natural or adoptive parents, the student is going to be a resident of the school district in which his or her natural or adoptive parents live. Now note, for this situation, it does not matter whether the parent moved into the district to gain access to the district schools.
That's a great point. So in the scenario that I posed, just because Aaron's parents say they moved here to attend the district schools, if Aaron is otherwise living with one or both of her natural or adoptive parents, they can be living within the district, even if the reason that they moved was to attend the district schools. And of course, that is a reason that many families actually move into a district neighborhood. But because that becomes a relevant point, as we'll discuss later, sometimes, we have a slight pause when we see that. But it is completely permissible so long as the student is living with one or both parents and they actually are living within the district. So Jared, can you continue taking us through the other definitions of legal custody?
Sure. So next is court-ordered custody. Now, if a court has granted custody to an adult with whom that student lives, then the student is a resident of the district in which that adult lives, as long as the student is not living with the adult for access to the educational programs of the district. So for example, if a court grants custody to a student's aunt and the aunt resides at an in-district address and the student moves in with the aunt due to the custody arrangement, then the student would be a resident of the district. Now note that this is court-ordered custody and not guardianship, which we will discuss next. But typically there will be some sort of documentation from a court or the state to show this. So next is guardianship. If an adult has been granted short-term guardianship, then the student is a resident of the district in which that adult lives. Again, as long as the student is not living with the adult for access to the educational programs of the district. Now, an adult's written appointment of short-term guardianship is sufficient to enroll a student, but the adult will be required to obtain a court order granting permanent guardianship within 60 days of the enrollment of the student. Now, note, failure to do that cannot lead to disenrollment of the student. So next is a relative receiving public aid. So if a student lives with an adult relative caretaker receiving aid under the Illinois Public Aid Code for that student, then the student is a resident of the district in which that adult lives. Again, as long as the student is not living with the adult for access to the educational programs of the district. So again, here, there will be specific documentation that the adult can show to prove this. Now, finally, number 5 is this catch-all. And that's if the student lives with an adult who has accepted responsibility for the student and provides the student a fixed nighttime abode, then the student is a resident of the district in which that adult lives. as long as the student is not living with the adult for access to the educational programs of the district. So notably, if someone comes to register a student under number 2 through 4 on this list, but they don't have adequate documentation to establish residency under either court-ordered custody, the short-term guardianship, or receipt of public aid, then the district will still need to analyze whether the student falls under the catch-all of number 5. So again, note that for numbers 2, 3, and 4 here, the court-ordered custody, short-term guardianship, or receipt of public aid, documentation provided by a court or the state will be sufficient to prove the relationship with the child.
Great, thanks, Jared. And then if we kind of go back to those scenarios I posed regarding Aaron, if Aaron's mom says the student will actually be living with the student's aunt who lives in the district while the mom resides out of district, and it's unclear whether the aunt has short-term guardianship over the child, then the questions to consider really are, first, if there are reasons to believe that there is a short-term guardianship in place, then the documentation submitted by the family really should be closely scrutinized to ensure that it meets the necessary criteria under the school code for residency based on short-term guardianship as Jared described. Even if there is no short-term guardianship asserted, Aaron might still lawfully attend the schools in your district if Aaron is living with the aunt and the aunt has accepted legal responsibility for the student and the student has provided a fixed nighttime abode with that individual under that number 5 catch-all category that Jared just took us through. Factors to consider here in terms of, are they really exercising the requisite responsibility over that student? Is really, sometimes what we think about in terms of how much decision-making authority does that adult truly have over the student, such as, decisions with regard to education, attending parent-teacher conferences, being the person who the school and the teachers are supposed to reach out to when there's an issue, or who has the decision-making authority when it comes to medical decisions. Or if such decisions are really still retained by the parent and the student is just sleeping at the family member's house. The more decision-making authority we see that the person who the student is living with really has will support more of a determination that they actually are exercising that requisite legal responsibility over the child, to find that particular provision would apply. Again, there also must then be an analysis as to whether the student is actually living there for a reason other than to attend the schools in the district. If you do have our toolkit, we do actually have a particular form that's designed to provide parents as well as the adult living with the student in these situations to have them complete, sort of try to probe to get at some of these, this information that I've described to really help ascertain the necessary information the district needs to truly assess that residency situation. Jared, can you share any other tips for documentation to keep in mind?
Sure. So for documentation, note that while a district may request a parent or guardian provide specific documents to verify residency, schools may not require an exhaustive list of documents. So a district can't mandate that parents or adult caretakers provide any particular documents such as a lease, a mortgage documentation, a driver's license or state ID card as proof of residency. But districts can, however, accept those documents. But the documents required by a district as proof of residency, they must be sufficiently variable to allow any resident to meet the residency requirements.
That's a great distinction, so that even if you have forms that ask or even require parents to provide different things, you have to be mindful that we might not be able to provide those exact forms if a parent gives reason that they are not able to do so, and there may be a requirement to work with them to identify, what is available. That's why you might even see in a lot of your forms, even a catch-all provision that directs parents to contact the school if they have any questions or difficulty with providing any of the information. So with that, we do want to just briefly touch on what the requirements would be for students who may have an IEP and how those might vary. And so this is particularly, we see these rules specifically in Article 14 of the Illinois School Code. And for students eligible for special education services, residency really is generally governed by guardianship rather than custody, as Jared described. So we don't often see this making that big of a difference with our typical residency situations, but it's important to keep in mind, especially when there is a more nuanced issue, that the school code does provide that the resident district for a student receiving special education services is the district in which the parent or guardian resides when the parent has legal guardianship of the student and resides within Illinois. And this is really that kind of most straightforward scenario, or if the other scenarios that we have here might apply. If an individual guardian has been appointed by the courts and resides within Illinois, if a public agency has legal guardianship over a student, or if there's a court order for residential placement, that's when some of this other criteria can come into play. Now, what happens if the parent or guardian's location is unknown, or if the student's over 18 or emancipated? In these situations, then the resident district is deemed to be the district in which the student resides. So in our situation for Erin, if Erin's mom or Erin herself gave a reason to believe that they actually did not live where they say they did. So let's say that even under looking at both, sets of rules, there's reason to believe that they're actually not living where they've otherwise presented as saying that they live, such as only staying there in the district home during the week to attend schools, but really living in the other home more permanently. That's when having a detailed questionnaire or affidavits can really help, and if necessary, considering initiating an investigation to get further information can be really helpful. Ultimately, because some scenarios may be tricky, sometimes there may be new scenarios that staff has not seen before. It can always be helpful and advisable to reach out to legal counsel to also help work through different issues, and even to help know when you might have sufficient information based on what they provided, or when it's a circumstance that would really be appropriate to try to get more information from the family or to perhaps initiate an investigation. Now, if Erin's parents said that they shared housing or home with another family and were living with another family within the district, that's permissible, and if so long as they're actually living with the family who in turn lives within the district. But it's important to note that if they are doing so for economic hardship reasons, that would be one of our red flags that the student may qualify for homeless education services under the district, and that may trigger some additional requirements. So Koga, can you talk a little bit more about those requirements?
I can, thank you, Amy. So under federal and state law, homeless students are defined as students who lack a fixed, regular, and adequate nighttime abode. This definition includes children and youths who are sharing the housing of other persons due to the loss of housing, economic hardship, or a similar reason, are living in motels, hotels, trailer parks, or camping grounds due to the lack of alternative adequate accommodations, are living in emergency or transitional shelters, or are abandoned in hospitals. This definition of homeless students also includes children and youths who have a primary nighttime residence that is a public or private place not designated for or ordinarily used as a regular sleeping accommodation for human beings, children and youths who are living in cars, parks, public spaces, abandoned buildings, substandard housing, bus or train stations or similar settings, and it also includes migratory children. It's important to note that there is no specific time limit on how long a child can be considered homeless. School districts have an affirmative duty to identify homeless families within the district. Now, if a student's circumstances lead a school to believe that the student is homeless, the school must immediately enroll the student. The mandate to immediately enroll homeless students also extends to students about whom the district receives any facts that suggest that they might be homeless. That means any facts that suggest that the family is sharing housing because of loss of housing or economic hardship, or that the student lacks a fixed, regular, adequate nighttime abode. Once the student is enrolled, the school must provide the student a notice of educational rights, connect them to the school or district's homeless liaison, and help connect the student with transportation and other services as needed. The school may be required to sign a statement verifying homeless status for a family experiencing homelessness so they can obtain a free birth certificate.
So in light of what Koga just shared, that in the scenario with, the student Aaron that I posed, even if Aaron's mother does not say they are homeless, if they assert facts that would meet the definition of homeless, the school would have an obligation to identify them and provide the services that Koga described, or at least offer to provide those services. So Koga, I'll turn it back to you.
Okay. A school district may enroll a homeless student in a school of origin or in a school to which the student is eligible in the student's attendance area. Ultimately, it is the family's choice whether the student is enrolled in either what is considered to be a school of origin or a school in the attendance area. The school of origin can be the school in which the student was enrolled when the student was permanently housed, or it can be a school in which the student was last enrolled. The school in the attendance area is any public school that non-homeless students who live in the attendance area in which the homeless student is living are eligible to attend. The homeless guidance refers to the best interest of the student with respect to schools, but the law has been consistently interpreted to allow a choice between the school of origin and the school of the attendance area. Now, as previously stated, districts have an affirmative duty to identify homeless students. However, please bear in mind that in most instances, families are not necessarily going to say that they are homeless. Therefore, staff should learn to identify common signs of homelessness. Staff should also double check all families that are enrolling in school that are sharing housing to rule out homelessness for those families. Additionally, districts should not engage in residency proceedings if the district disputes that a student is homeless. Rather, the district should engage in dispute resolution.
Thanks, Koga. And this is, important to keep in mind. As I had mentioned earlier, there is a, very particular procedure that we have here in Illinois that really governs what that dispute resolution process looks like. And that that's laid out in that policy guidance document that I mentioned earlier. That does require certain things occur in certain steps, including coordination with the ROE. And ultimately, if a dispute appears to not be able to be resolved between the family and the district, then an initial step to trigger that dispute resolution process is actually sending a notice to the family that does have to include certain criteria that's set out in ISB's policy for that dispute resolution process. And then that would then trigger, if the issue is still not resolved, the matter going possibly to a hearing before an ombudsperson that's appointed with the applicable ROE. And during that time, a student has to remain enrolled until that process is determined. So that's an important step to keep in mind, especially when you might find yourself being at a situation where you find there to be a dispute regarding a student's eligibility for homelessness, and that may really determine whether a student might actually be eligible to attend the schools of your district or not. And in that scenario, really to help make sure that you're proceeding in the best way, really working with legal counsel to even prior to sending out that initial notice can always be a best practice to make sure that you're following the procedures that are necessary when you start to make those steps. As well as that can also help just to review kind of, where you are substantively in terms of the information that you have to make sure that it is, that you do have the needed information to then move on to that next step. I know some of you have really, nice and frequent communications with the designated homeless liaisons at the ROE and your district. And that's always great to be able to help make sure that you're following what you need to do to support your students, and that the ROEs in turn know that you're taking those steps as well. I also wanted to note here that while Koga mentioned that there is no time limit on homelessness, remember that under the school code, or really under our Illinois Educational Act that supports homeless students, that families that are sharing housing, if they have been sharing housing and it's been 18 months since they have been doing so after first coming to your district, you can ask them to sort of provide information to reassess whether they would still meet that that definition of homelessness. If you have our toolkit, we also have a sample sort of notice that can help guide you, with that process as well. I see one question that's asked for the names of the documents we've mentioned earlier. So one is it's a residency guidance document. I'm going to pull up the exact name. It's ISBE's non-regulatory guidance that's entitled registration guidance, and then it's residency and enrollment, immigrant pupils, homeless pupils, and school fees and waivers. If you go to ISBE's website and go to their page where they have their non-regulatory guidance listed, then that is in the section of their non-regulatory guidance on their website that just doesn't have a date to it. It's just sort of up there now. They used to issue that every year, and it looks like it's just now a standing document. The other document is ISBE's policy on homeless students. Again, if you go to their landing page on ISBE's website, that's specifically addressing services for homeless students, then that can be found there. You can always also feel free to just reach out to any one of us, and we would be happy to provide that to you as well. But I would just say, as another point, that in addition to issues that may arise in terms of eligibility for students who are homeless or not, also, if you find yourself at a point where there might be a dispute with the family with regard to their residency status and eligibility to attend your district tuition free, prior to initiating the steps that need to be taken under our school code to proceed with potentially making a determination that the student is in fact not a resident, and proceeding with a disenrollment and tuition collection process. It's a great, another great, kind of best practice to touch base with legal counsel prior to initiating that process. One, so again, you can make sure you're following the procedures that you need to when there is a dispute with a student's residency status. Under the school code, as many of you know, parents do have a right, once they've been attending the schools in the district, to have a hearing if there is a dispute on the student and parent's residency status. So there's specific notices and procedures that have to be followed to make sure that parents are getting all of those rights and that we're meeting those requirements. So touching base with legal counsel to make sure you're meeting all of those is important. And then it can also be a nice step to also just work with counsel to review the information that you've got to that point to, again, make sure that you have the needed information, when you're going to be moving forward. I do see we've got a couple questions. One is, just the recommendations we have for schools when the parents and students are living with a relative in the school's boundaries, and we might not have that necessary proper paperwork. That's where we really recommend, again, asking the parents to provide more information really about the circumstance that they are that they are living with the family, to really be able to help make sure that they are actually living with the family that they've shared, or that they've said that they are, and then also to help make sure that if there's any services we need to provide for them, if they did qualify for homeless education services, which they may not always. But so, for example, in our toolkit, we've got a form for families to fill out in this scenario that really asks a lot of questions about sort of the comings and goings of the families, and to really get a sense of how often they're staying there, to really try to get at the heart of if this really is truly their regular nighttime abode. So trying to really get more information like that can really help then the district see if they've actually got that information, especially when they might not have a formal arrangement with living with that family. I also saw a question about guardians who might be separated but have joint custody, and those issues. So we do actually have a provision in the school code that's specifically applicable to, or in the section 14 of the school code, that says in those situations where a family is, where parents have joint custody of a student, then, and it's truly that equal situation, then essentially the student could attend one or the other district if the parents live in different districts, so long as they choose one and aren't going back year to year. So that, that's specifically then in that, like I said, that Article 14 of the school code. I know a lot of times we get some tricky questions that arise about those scenarios. So again, it's always helpful if there's something unique about it to bring that forward to council. So with that, we will end since we're at our time, but we thank everybody for attending today. Feel free to reach out if you have any other questions, and good luck with the start of the school year for all of you. Have a great day.